So this person is saying that he might have gotten an attempted aggravated S battery charge because a bullet that somebody else shot, because remember, Tonk was not the shooter. Somebody else shot, hit somebody, and came out of a sensitive private part of their body. And we are back, Go ahead and hit that like button, y'all. Today we're going to be taking a look at a couple of big moments from DA Abate, who looks like he's poised to take over the YSL RICO trial for the remaining 5 defendants, including Miles Farley and Demikion Garlington. So just want to shoot into kind of a back and forth that went down on X over the last few days about whether or not the public should trust the DAs outside of Hilton and Love. So Amy D made this post. Max and Doug are giving a lot of grace to the state. Amy says Amy can't. They are all complicit compared to the Baldwin case. Second prosecutor quit because she knew that Morrissey was being unethical. That is what ethical people do. I have no grace for Hilton, Adkins, or Abate. Doug comes back to say, so these things are easy to say and feel. We're all upset at some of the actions of the state, but we should appreciate who pushed those. It's easy to say quit, but we don't know folks' circumstance. Life is so complicated, we don't know what people are going through. Haven't you ever said something and then later learned the subject of your wrath was going through things? Let's give folks a break. Now, I do certainly encourage you to take a look at this thread, and I will post a link to the thread in the description. But what I want to do today is I want to take a look at a couple of notable moments from Abate. I think my personal opinion is DA Love got the most of the scorn because, frankly, she deserved it. I was more lenient on Hilton, but over time, especially going into the final weeks of the trial, when it was clear that Love had been sidelined, Hilton picked up the mantle and she ran with it. Abate seemed to be more of a professional prosecutor, kind of just doing his job. But there are some significant moments where Abate stood first and foremost in our consciousness, and we're going to take a look at a replay of those right now. One as it relates to Thug's watch, when Abate apparently pulled up a Richard Mille white Bubba Watson. It looked like the type of watch Thug had. We don't know if it was one of Thug's watches or not, but he looked like he was pulling it up from the inventory on his computer, like looking at photos of inventory. And we discovered that live on the stream. Not that he was looking at it, but we kind of figured out, hold up, is that inventory? Because I'd always thought it was a Google search. And then we're going to look at what Abate did to Monk Tonk. And I think this is where a lot of people really say they can't forgive Abate, because it looks like Monk Tonk may have gotten a harsher sentence, perhaps due to the way his case was presented. And you're going to see that in the video coming up as well. So want to thank you for riding with us this whole time. Of course, don't forget to like, comment, subscribe, and let's just get into the video.
Thank you.
So this is Abate looking up the watch.
You can charge Max for that.
Y'all, hold up.
Would you point out again where you first saw Mr. Kendrick?
Hold up. Is this a Google search he's doing? Is that a Google search, or is he looking in inventory?
Thank you.
It's not quite, y'all. It's not clear to me. It's not clear to me that Abate's looking at a Google search. It might, yeah, it probably is a Google search. Probably is a Google search.
You can charge Max for that. Would you point out again where you first saw Mr. Kendrick?
So Abate is going to take a picture. Y'all, is that a Google search or is that inventory? Okay, now this is something that never jumped out to me until right now. I can't tell. Is he looking at a Google search for the watch, or is he looking at what should be in? Yes, Steven, that's the question, or Stefan. However I'm supposed to pronounce it, you let me know. Stefan. Yeah, he looks like he's looking at inventory. I always imagined this was a Google search, so he's like, hey, what does that watch look like I did. But it looks like he's looking at inventory. Morning, Terrell. That is a little different, isn't it? Because if he's looking at inventory, that means that they actually did seize the watch. Like, in other words, it wasn't just that Thug misplaced it, or, you know, there would be no question as to whether or not they seized it. Y'all, this is crazy. If that's an inventory, if that's not Google, if that's inventory, that would mean that they actually have it in their possession. But Detective, Storno said, this is everything we seized, and it's not in the bag. That's crazy. Y'all, we just truth sleuthed. Miss Lily, we just truth sleuthed. I'm going to back it up a little bit.
Thank you. You can charge Max for that.
That doesn't look like a Google search to me, but you can't tell.
Would you point out again?
It does kind of look like a bunch of images of the same thing from my perspective. It looks like a bunch of white watches.
You first saw Mr. Kendrick?
So, but how does it pop out like that? That's my question. Like, usually if you're doing a Google search, it'll pop up in the Google window. But is he using a Mac? For all of my Mac users, is he using a Mac, and is this how it comes up when you do a search? For all my Mac users, because dear woke Christian, good morning, sir. So for all my Mac users, I'm not a Mac user, so I don't know if this is how things pop up on the Mac. So that would be a question. But it does at least tentatively look like he might be doing a review of the inventory that they should have in their possession. And if that's the case, this would be pretty strong evidence that the watch was at least misplaced. Yeah, y'all, please do hit the like button, y'all. We just hear pocket watching Thug a little bit this morning. You know, somebody with tens of millions of dollars. We just pocket watching. We're going to get into a list of everything they seized from Thug here shortly. We just kind of letting people stream in a little. And we are looking at Abate, and he is either looking at some kind of search. Let me see. I have a Mac. I checked the images on the computer are file pics in a folder. Oh my gosh. Oh my God. Now, again, I went back and I did this zoom in on my computer, but I originally saw that somebody else had on X, and I wish I knew who it was. Sorry. Again, I'll do better writing people's names down so I can give people credit. So I saw on X somebody was like, yo, Abate's checking out the watch. As a matter of fact, let me see if I can find that post just so we can shout that person out. So I went back on my own computer and I just zoomed in myself, right? And I never thought, though, that he might be looking at inventory until right now. I always thought he did a Google search. That's what I did. I was like, oh, let me see what that watch looks like. I figured Abate was just like, hey, what's that watch look like? You know, because you're kind of curious. It was a very specific thing that Weinstein said. But now if we conclude he's looking in a folder with images that if you look at this, it does kind of like, who would take a picture of an expensive watch with this just random black background and with the watch off to the side a little bit? No, he didn't take a screenshot. He took a picture with his phone. We're going to see that in a sec. He took a picture with his phone.
Can you turn the other way so that you can kind of be facing the jersey?
Oh my gosh, y'all. What if they stole? I mean, I know I put stole in the, on the thumbnail. I put stole on the thumbnail. I'm being a little bit provocative, y'all. I'm being provocative. Abate is literally showing the world like, yeah, we have this somewhere.
So they can make sure they hear you talking.
First time I saw him, he was
He took a picture.
over here, I believe.
Okay, thank you. Did you see Mr. Kendrick exit the house?
No.
Yo, this
Okay.
is so
Okay.
wild.
And you can be seated. I don't believe I have any more questions that require you to stand.
Let me see if I can find the person
And
who originally.
did I also hear you say that Mr. Kendrick was not armed when you apprehended
Yes.
him? Okay. Do you remember him telling you that he was scared
No.
and wanting his mom?
I remember him calling his mom.
Okay.
Okay,
Thank
y'all.
you.
So Abate looks at the watch. That definitely does
I have
like
no
a
more
file
questions.
folder
All right.
more so than
Ms.
it
Shardy,
could be a Google search, but
questions? All right, any redirect?
we have people
Okay,
here.
thank you for
saying
your time.
They
You
have
may
a
step
Mac, and
down,
that's
call your
how the
next
files
witness.
come up.
Now, we all remember a couple of days ago, Monk Tonk was sentenced to prison. We all remember just how terrible it felt to see Monk Tonk locked up and about to go straight to prison to serve anywhere from maybe up to 5 years, probably less, but he had 5 years of his probation revoked right there before our very eyes, and we felt terrible for him. Now, part of having Monk Tonk sentenced to this 5 years was the reading of his rap sheet that happened right in court in front of everybody. I want you to take a moment and I want you to listen to this entire thing. Listen again, okay? And you can see on your screen why I'm asking you to listen to this, because someone on Twitter, on X, BEA_L. I'm not going to try to pronounce it, but y'all need to go follow her. You can see her Twitter page on the screen here, BEA_L. She went and pulled up the actual charges. She pulled up the rap sheet. She pulled up the document, at least one of them, that was referenced by the probation officer, and she found something very interesting. One of the most heinous crimes that the probation officer mentioned when she was telling Judge Whitaker about Monk Tonk's previous criminal history, one of those crimes is not how she said it. The way she mentioned it out of her mouth and the way it comes up on the rap sheet is two different things. So I want you to listen, watch and listen to everything she says first, and then we're going to come back.
All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb,
Since you're only supposed to get to use it once. Okay.
yes. So the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon. That was January 10th, 2018.
All right. So given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th of 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I
SC.
figured there had to be something else there. Okay,
Sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe that it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation.
All right, now that we're back, you might have noticed today, maybe you noticed previously, that she says there was an S battery. Now, y'all know what the letter S stands for, and if you don't, get with it. This is YouTube, so you can't just say whatever you want to say. She said that Tonk had an S battery, y'all. And I'll tell you what, when I was listening to that on live, I said, did she say 6? The number 6? And people were like, nah, she didn't say 6. And I'm like, I hope she said 6. People automatically kind of started turning against Tonk. And they were like, hey, well, if he has one of those in his past, I don't feel bad for him. You know, let the things be, let the chips fall how they may. Let the thing be what it might be, you know. In other words, whatever's going to happen is going to happen. I'm not going to worry about a person with that in their past. And a lot of people felt that way, and I think most of us can kind of understand that, right? If you have one of those charges in your past, you're not going to gain a lot of sympathy from people. But look at what I Stand This YSLD has uncovered. She, and I'm going to say she because this does appear to be a woman from the photo, she has actually gone and found the actual document that lists all of the charges from 15 SC 13-8-89-94. Okay, this was if you go back, and we'll play this one more time at the end so you can listen again. We'll play where the probation officer reads, or the parole officer, whichever type of officer she was, where she reads all these charges. We're gonna play it again. She mentioned an attempted aggravated S battery. Look at this document, y'all. There is no attempted aggravated S battery on this document. The only aggravated battery there is this one here. This is the only aggravated battery. You have some aggravated assaults, but you don't have any other aggravated batteries except for this 16-524. I pulled up the 16-524 and check it out. You do a search for the S word on this document, it does not come up. This is not an S battery type of document of a statute. Okay, this is an aggravated battery statute, but it's not an S battery statute. So you have to wonder what's going on. Why did she mention that? So you have to wonder what's going on. Why did this lady mention that? Well, there's some theories here in the comments. Now, by the way, this wonderful piece of, I would call a reporting investigation only has 10 comments. Y'all go check I Stand This YSLD out and comment on her story. The first person here, the first comment, I should say, this wasn't the first comment, but the top comment says he got the aggravated battery charge because the bullet that hit Denise Bell went through her. So it went, I think, through her behind and it came out the front. If you know what I mean, use your imagination. By the way, you can see it on your screen too. So this person is saying that he might have gotten an attempted aggravated S battery charge because a bullet that somebody else shot, because remember, Tonk was not the shooter. Somebody else shot, hit somebody and came out of a sensitive private part of their body. And he might have gotten an attempted aggravated S battery charge for that. And then, of course, you get the obligatory insults to Monk Tonk's attorney, because you would imagine an attorney would never let that kind of thing fly, right? So here we have what seems to be proof that while Judge Whitaker was making her decision about Monk Tonk, there may have been information, I'm saying may have been, I'm not saying was, because this is just a certain perspective or angle, but it looks like there may have been information that she was presented that was not correct. And did that factor into, how much did that factor into her making her decision? It definitely factored into some of the opinions of the people who were watching at that time, who some people turned on Monk Tonk immediately when they heard that. Now it looks like that information may not have been totally correct. So again, we want to give credit where credit is due. Y'all go follow at BEA_ELLE on X. Please do like, comment, and subscribe. And I'm going to play one more time this officer reading Monk Tonk's charges. And I want you to let me know what you think about this situation. Thanks for watching.
All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky.
The DeKalb,
since you're only supposed to get to use it once. Okay.
yes. So the DeKalb County case 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on, so the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it. One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th of 2014, which would be the predicate or basis for the possession of a firearm by a convicted felon of the 15
I
SC.
figured there had to be something else there. Okay,
Sorry, I should have spoken sooner. I apologize.
appreciate it.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it, the state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked, is that right?
It's not the request.
Or is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number. Ramona. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many reasons why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble in and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he
reinstating
will be
the balance.
continued on probation, Your Honor?
And reinstate the balance.
Your
Thank
Honor,
you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Not on Zoom.
I don't know, the sound in
Dolly
this
had
courtroom
bad.
is...
Go to the next room.